Welcome. This is the Domain Name Law Show. We welcome everybody here. We do this every Tuesday, noon Pacific, 3 p.m. Eastern. There's three hosts to this show. My name is Todd Ryan. My co-hosts are Jeffrey Neuman and David Michaels. I always say hi to them before we get rolling. Hi, Jeff. How's everything going today?
Yeah, everything's good. It was a real busy week last week. Probably going to keep getting busier the rest of this year, but we're going to talk about some of it on today's show. Looking forward to it.
Yeah, we got a lot to cover. Um, and David, how's everything going with you today? What's up?
It's just a nice, sunny, beautiful day here outside Toronto, and looking at all these cases, it's like a lot. But I'm interested in hearing from Jeff. Is there any updates on the Calor case?
Yeah, I mean, updates. We are no, it's going to be a while for updates. We're in discovery, so it's going to be a while. The There is a order, so I mean, if everything goes through till the end, it would be a trial next year and or sorry, 2 years. 2027, yeah. First quarter 2027, but we'll see. We'll see how far we get.
Yeah, and Jeff, I had my very first thing on my notes was, did we talk about the Prosecco case? And I know we didn't. I'm going to add that to the agenda, but we're going to talk about that. Matter of fact, we're going to talk about it first, and then we're going to talk about the Blockchain.ai that everybody's been talking about. But so this, I think we may have touched on it. I guess not, but it was definitely something that I meant to have highlighted. So this case, Prosecco.com. Prosecco.com is one of the domain names in question, but long story short is Jeff is representing a plaintiff in a case, or you're representing the defendant actually. So this is a little different. Best Foods is
No,
the
no,
defendant.
you're right.
Oh,
You're right. I'm representing the plaintiff.
okay. Well, tell us about this case, a little bit of background, because it is about a domain name or two, and well, tell us what's going on. Very interesting case.
Yeah, this case, it seems like some interesting cases. This case was filed in the Eastern District of Virginia, and is awaiting a TRO, temporary restraining order hearing, which is actually scheduled for Friday. Um, this is a case but from the owner of the domain names Prosecco.com, ProseccoDoc.com, and other Prosecco related domains, who has been for several years been um, harassed by the consortium in Italy, the Prosecco Consortium. I'm not going to try to pronounce the Consorzio um, Italian name for it, but the Italian group has sued um, the former owner of Prosecco.com, not knowing that the current owner is who he is. So sued the former owner in the UK, and they chose specifically the UK because the UK is much friendlier towards geographic related indicators. So Prosecco is a geographic indicator that has rights in certain countries where they recognize those rights. The UK is one of those. The United States does not happen to be one of them. And in fact, in the United States, the consortium did apply for a trademark for Prosecco and as a certification mark, and that was denied. The consortium applied or appealed that which was denied, and then they did another request for consideration, and that was denied. So basically, the term Prosecco is not protected in the United States, but may be protected in the UK. So the consortium, despite knowing that the plaintiff, Best Drinks, owns the name, has sued the former owner of the name in the UK to try to get a finding in the UK that the domain name is infringing its rights in the geographic indicator, hoping to serve that order on the registrars here in the US to force the transfer of the name. So in order to put a stop to that, we filed for a temporary restraining order in the United States in the Eastern District of Virginia, where the plaintiff happens to have their business registered. And the reason why it's urgent, for a temporary restraining order is that we want to make sure that if the registrars in question, Network Solutions and GoDaddy, receive a order from the UK court to transfer, that it won't actually transfer name until the US case is heard. And so the US case ultimately is seeking a declaratory judgment that the ownership of the domain names, the Prosecco related domain names, do not violate the rights of the consortium.
So, for those who don't know, so prosecco is a wine, a sparkling wine. I see dry sparkling wine, but it's from an area originated in Italy, and so it's like champagne, right? That type of name where they or Napa, certain types of. Basically, what do they call that, Jeff? When you have this product or like champagne, what is that called? It's this certain region, so they feel like you can't use
Yeah, they
champagne.
are, and they are protected in certain countries in Europe, like in Italy, for example. They're called geographic indicators. And so, yeah, like champagne, in fact, even like brie cheese and other types of cheeses are protected in certain countries. So you can't use some of those geographic indicators without, getting the rights to do so from an official organization. Prosecco happens to be a geographic indicator that has for which the consortium may have some rights in those countries, but certainly that is not recognized by the United States under various treaties that the U.S. is a member of.
Interesting. So, have you considered doing geo-blocking so that the UK residents cannot see the prosecco.com domain name or any of the other Prosecco domain names? Because that became a factor in the Visit Qatar case where the judge issued, a UK judge issued a order that the website should be not available in the UK. So basically a blackout order for the UK IP addresses.
Yeah, so the plaintiff or Best Drinks has UK counsel that is, making all those arguments in the United Kingdom. And basically, what I'm trying to get the court to do is separate any claims of infringement from the ownership of the domains. In other words, the UK court can continue to do what it's doing, find infringement, not find infringement, whatever. But whatever it does, it can't order a transfer of the domain names because they're owned by an American organization. And in cases like Barcelona.com and another case in Virginia called HAWES, Hawes, that case, the courts are very clear that the United States law controls property which is in the United States, and domain names are that kind of property. So we're separating the whole infringement arguments from ownership of the names, right? So if the UK court finds infringement, now I'm not saying they should or shouldn't, they got UK counsel and hopefully there is no infringement, but if there is, a remedy should not be or cannot be ordering the transfer of the domains.
And
Hope that makes sense.
yeah, it does.
Cool. Well, good luck on that.
And the UK court feels like they have jurisdiction. It's because a couple of the folks that own the particular domain name live in London. Why does the UK court feel it has jurisdiction?
Well, so the UK court hasn't determined that there's jurisdiction yet. It was just filed in late August, and the defendants in that case, who happen to be the plaintiffs or the former owners, but yes, there is some ownership in common where the people that were sued in the UK are one of them is a member of the US LLC, and another one is the manager, but not a member, meaning they don't own it, but they run some of the day-to-day activities. So the UK court, again, it hasn't determined it's got jurisdiction yet because it was just filed, and I'm sure the defense will likely include the fact that there's no jurisdiction. But even if it does say it has jurisdiction, which, by the way, every country has sovereign rights to jurisdiction over activities that are in that country. So, whether it violates the UK laws or not, or whether it's infringing, the UK court's got every right to determine that for what's within its borders. But my argument is that the domain names are not within its border. So even if there's infringement, yeah, you can find infringement, I guess, in the UK, but you can't order property or domain names that are in the US to be transferred as a result of that. Otherwise, you, in theory, could have, you know, this battle in every single country, and it could every country could order a different transfer of the domain. And so the US law controls who owns the domain names in the United States. And but yeah, you can have a site up here, um, and you could be reaching out to UK residents or whatever selling products, and sure, the UK courts could exert jurisdiction and could find you infringing in the UK, in which case, one of the mechanisms may be, as David said, to block it in that country, or some other, or even payment of damages to an owner in that country for activity in that country. Every country's got jurisdiction of what happens within its own borders.
Right. And I just wanted to mention to the crowd listening. So we're talking about a domain name here in Jeff's case, and it's prosecco.com, and one other one,
It's
PRSECCO
Prosecco,
DOC.
Prosecco DOC, which is used sometimes as a certification of an official Prosecco product. Um, and then there's some other Prosecco related names that are, as well included in the U.S. lawsuit that Best Drinks, the plaintiff, owns, that we're trying to protect as well, even though they may not have been specifically named in the um, UK case.
I see. And
So in
Best Foods.
2021,
Go ahead.
the Department of Environment and Food and Agriculture Rural Services in the UK issued published geographic indication called Protected Designated of Origin. That's a PDO. Country of origin is Italy. And so anything that's sold with a Prosecco name has to originate from Italy. That's what it says on the registration. And this was published in 2021.
Right. And so, and again, separate that from the plaintiff, who actually, not through the website, but through their activities, does sell official Prosecco products that are made in Italy. And so that's not even in question, right? So they're complying with the PDO. It's just that the consortium is now going one step further and saying that the PDO protects even the word Prosecco, and that Prosecco.com has that word in it and therefore should be the property of the consortium.
And Jeff is on the offensive here with Best Foods, representing Best Foods as the plaintiff, Best Foods, enormous company, saying, listen, no matter what happens, like you said, Jeff, no matter what happens in the UK with regards to this infringement case, the domain name is property of Best Foods. It's not something you can take away. And we just want to make sure that the court rules on this basically before anybody starts ruling differently in some other jurisdiction around the world. So really taking the offensive. Jeff, you've been involved in a lot of cases. So this one we're going to follow, prosecco.com. It really is important to domain name law. And the other one that David asked about, that Calor case, for those who don't remember that, that's the one where the gentleman won the domain at auction, through GoDaddy, started building on it, doing some work, developing it out, and then, as they say, GoDaddy clawed it back. And um, so there's that. That's an ongoing case. Jeff will give us an update on that when there's something to update. But people are looking closely at these cases. This Blockchain.ai case, very interesting because it's another one that's going down now. Now, okay, so you were part of this case, and you really still have some involvement, meaning you were the original attorney for this Howard, who is now filed a lawsuit against just, or I guess it's called Only Domains and Namecheap and so on. But just a real fast recap: Blockchain.ai was just sold via auction at Namecheap, $405,000. A lot of us were watching it. Well, right at the end of the auction, we see that there was a case filed in the Northern California court by, was it by, oh, it was by Mike Rodenbaugh, and it's basically
It's not
saying that,
Northern, it's Central District, which is Los Angeles.
oh, it was right here. Well, Jeff, I know you know plenty of the background here, and David and I have read up on it, but tell us a little bit about, your involvement at the beginning, how Mike takes over, and really your thoughts on this case.
Yeah, so at the beginning, when I got it, which was I think mid last week, um, or maybe even Tuesday, it all happened really pretty quickly. Um, at that point in time, yes, there was a listing on Namecheap auctions for the name, but and so I took this case pretty quickly because Howard owned the domain name blockchain.ai, and he had that name since 2017. It was on auto renew, and it was auto renewing every, I think, 2 years. Maybe it was every year or every 2 years, and everything was fine. Then all of a sudden, um, Howard gets a note in September, um, after looking at his portfolio, essentially, and it said that the name was not renewed. And so he contacted Only Domains, which is the registrar, and said, "What's up?" They said, "Oh, your credit card had expired, and so we weren't able to renew the name." And so the name technically expired in July, but was in the expiration um, period where you could redeem the domain name. So when he found that out, again, he wasn't told it didn't go through until September, which is not good on the registrar's behalf. Um, so he asked and got an invoice and paid for it immediately upon finding out, and got back a receipt that said, "Okay, it's paid." And for the next couple days, he was looking at the status of the domain, and it just kept saying pending, pending, pending. He contacted them, said, "Why does it still say pending?" And they looked into it, got back to him, and said, "Oh, you didn't pay the restore fee." And he said, "There's no invoice for a restore fee. I'll pay it, but why is there no invoice that asks for the restore fee?" And they apologized. They said, "Okay, sorry. Here's just take the name, or just pay the restore fee." They gave him the amount and pay through PayPal, for which he did, and he got a receipt for it. The next day, after he paid, he finds out that the domain name went into pending delete status and was listed on Namecheap for auction. But he clearly had receipts, and the receipt said paid. And, so it was through no fault of his own that it went into pending delete. And so I contacted Identity Digital. I contacted, of course, Only Domains. I contacted, and I CC'd Namecheap so that they would be aware of what was going on. And I was hoping that Identity Digital would stop or change the pending delete status into, um, a status of registered or active, which only the registry at that point can do. Once only domains put it into a status called pending delete, it lost all control of the name. And remember, this is a ccTLD. This is .ai. This is not a GTLD. And in a GTLD, it would go to the registry um, and be deleted, and then would just be up for grabs for anyone to register, right? Either through a back order or through the registrars. In this case, which I didn't know until after I sent the letter, was that Namecheap had an exclusive arrangement to auction all domains that are deleted and returned to the registry. So it never becomes first come, first serve. It becomes a Namecheap auction. In the meantime, I get a note back from Identity Digital saying, sorry, the ccTLD manager for .ai has decided that it's not going to intervene and the auction's going to happen. At that point, I called Mike because I have a conflict in being adverse to Namecheap because I had represented Namecheap in a matter in the past couple of years. And so just not to have the appearance of um, any conflict or any actual conflict, I gave it to Mike and I said, you take it forward. I'm off this case. And so, yeah, Mike then went forward and filed the document that we see linked there. And that's my involvement in it.
So you contacted Mike to file the case in California. Um,
Well, I
so what?
contacted Mike and gave him the case and let him. I didn't say, Mike, file this or do anything. I just said, Mike, can you take this case? And I handed it off to him. And then he made the decision to go
Okay,
forward.
so that means we can talk about it. Okay, great. So, um, yeah, we were discussing on the weekend whether or not, because I saw that Namecheap CEO his posts on X, and he was aware of a dispute, but he says there's no court order yet, and it appeared from his posts that his hands were tied and he just couldn't take it out of the auction without something more from the court. So I guess he was expecting a TRO and he never got it. And so I guess it's Mike's decision to file this case in California and not able to get a TRO for Arizona. And then, I was thinking about what are the merits of this. So if he were to file the case in California, he has extra remedies that are not available in Arizona, as you learned from your Calor case. And so I guess he's got his options open. He could have filed a parallel case in Arizona at the same time, but he didn't. And I think he was trying to block the auction. He was making everybody aware on X and elsewhere that, hey, this is a name that's, still belongs to Howard Gould. And, you know, buyer beware, you're not, this is stolen property, basically. And so I guess the reasoning is so that he could have his options open depending on who acquired the name. If it's an investor or um, an end user, then if it's an end user, he could claw back through a court case in California and win that way. But I think in the end, he's probably just going to get damages from Identity Digital. I don't know what Namecheap's contract is with Identity Digital. I'd like to see the terms of that contract because otherwise they're going to incur expenses if they're not indemnified. But it's an interesting situation.
Yeah, well,
Yeah, so they this all kind of came up really quickly, um, and by the time I found out that Identity Digital was not going to do anything, that was Friday evening, and so or late Friday, and so that's when I handed it off to Mike. And so filing, Mike chose to file for a TRO. You could file it, but the court's not going to hear a case on the weekend. And so Yeah, his decision, Mike's decision to file in California is interesting. Namecheap does have a location there, and I'm not sure if you know, we'll see what happens, but Namecheap does have a location there, and there is the Kremen case, and there's other cases in California where, yeah, the California courts do recognize the conversion theft of a domain name as property, and so you know whether they're able to get the domain name or back or they're able to get damages. I think it depends on how the fees are split between Namecheap and Identity Digital and um, the CCTLD manager.
Well, I got tons of questions here. So the CCTLG manager, is that somebody that works at Identity Digital, or are you assuming that's somebody over at in Anguilla in the government?
I think it's in Anguilla. I think the actual, I mean, Identity Digital's been hired as the contractor to basically do everything. But and I don't know, I haven't done research, but I do believe, and actually I could look while you guys are talking about this, I can look to see who the CCTLD manager is. But yes, I believe it is someone that is associated with the Anguilla government.
Okay, take a look at that, Jeff, because the questions that I have, and David, you can help me try to answer, but you and I will, okay, first of all, the agreement between Namecheap and Identity Digital. Let's assume it's 50-50. I know it's not, but I'm just saying that so people can understand. Let's assume Namecheap and Identity Digital split the proceeds of the auction, because that's why I'd like to know who gets that 400,000. Let's assume they split it. They each get 200 grand. And let's
Yeah,
assume,
no, I would put just, yeah, it is the government of Anguilla, the Ministry of Infrastructure, Communications, and Utilities.
okay,
So I would definitely assume that the government gets a portion of
well, sure, Jeff, what I was going
that.
to say then is let's assume that the Identity Digital agreement with the government is the government gets 80%. Because remember, Identity Digital was giving up a lot more than that previous manager or service provider who was handling that extension. So Identity Digital was like, we're going to give the government 80% of the money we make. I think it was might even been 85% or 90, but let's just go with 80. So if Identity Digital made 200 grand off of the sale of it, because that's like 50%, then they have to give up 160,000 to that CCTLD manager, basically Anguilla. So we're trying to figure out who gets the money, and the one who gets not necessarily the most, but probably in charge. Because when Richard says, and he's got some other partners are on the board there, my hands are tied. Tied by who? I mean, by the CCTLD manager. Is that really where the buck stops? Even though they're all splitting the money, so they're all getting a piece of the action. So it's not like there's an I would say the owner is Anguilla, okay, and that person. I'd like to know anyway
My
the
my
agreement.
guess, what I would say, this is just a guess. I don't know. I don't represent uh, them anymore. Um, but the real fault is, of course, the original registrar, only domains. So my guess is that if for whatever reason the there's damages that are awarded, my guess is that they'll look to the original registrar under their agreements and say, "Hey, not our fault. You deleted it. We just did what we did because you deleted it, and this is what we do with all deleted names. So, you know, pay up."
Yeah,
That's my
well,
guess.
it's possible that, and I would say Namecheap probably doesn't get 50%. Let's say they only got 20%. That would, to say we get 20% of any .ai auctions, or 25, it doesn't matter. They may even say that original registrar also gets 5% or gets some something, some part of the sale, as I don't know how they would list it. But anyway, so we know there's definitely Namecheap's making money off the auction. What percentage we don't know. 10%, 20%, probably not as much as 50%. And then we know Identity Digital gets some because they take the money and give it back to that CCTLG manager. But for for all of them to say, we know legally, sometimes you don't have to stop until he gets a court order. He doesn't have to stop that auction. But well, my question, Jeff, about when do you think we're going to get a decision on this TRO?
Yeah, I don't know, and I haven't looked at the file, but my guess is since there's a TRO motion, that's got to have a hearing pretty quickly. So at some point this week, if it hasn't already happened, but certainly pretty quickly, there'll be a TRO hearing. And then if I'm not sure you can get a TRO at this point since it's already been auctioned. Um, so it'll be interesting to see whether Mike can get a TRO. I don't know what it would stop other than maybe if the name hasn't been transferred over to the new registrant, perhaps a TRO to stop that transfer from taking place. But again, I don't know if the name's already been transferred over.
Yeah, so it's developing. We're going to follow this. Blockchain.ai sold for 405,000 through a Namecheap auction, and you saw basically the reason why they said it still went to pending delete. You sort of touched on it was yeah, he paid that recovery or whatever that extra charge is, and then they said, oh yeah, you're still missing $7. And he's like, I don't know why it would be missing $7, but I'll go ahead and send that over. And I did see the email thread that was an exhibit in Mike's case that really was from that you received from the client when you were representing him, showing that yeah, the registrar only domains was like, okay, you need to renew it. Oh, it was renewed. Okay, you need to pay this extra fee. Okay, you paid that. Thank you. Oh, it was missing $7. Go ahead. Okay, thank you. We got it all. But in the meantime, it was already, it moved to pending delete. And I love that you told us all once in pending delete, only the registry can change the status. And that's for a CCTLD, or is that for GTLDs as well?
That's for GTLDs as well. But in GTLDs, when it's in pending delete, it means that the registry has to then release it for registration. The registries do not auction. Well, I suppose they could reclaim it and then take it as a premium name and then auction it off. But either way, it's in the registry's control. Normally, like if this were .com and a name was in pending delete, it would be released 5 days later into the general public, and then of course you have all the drop catches there to try and get it.
Okay. If anyone has any questions, come up at the end. Ragu, I did see your request. I'll bring you up when we get through our cases because I want to try to get through our stuff today, and then we'll have questions at the end. Anybody has a question, come up right, and we're going to try to get through our cases pretty fast. If you want to follow along with what we're going to cover, you can go to the outline, dnlshow.com/outline, and we got a couple more news articles, and then we're going to get right to our cases. But we just talked about the blockchain.ai case. We're going to follow that closely and give you an update next week. If there's any updates, not even share it with on Tuesday, on Thursday's show with Josh. It's all domain news. This next case, real fast, Lamborghini. They had won Lambo.com in a UDRP. The owner of Lambo.com, who bought it for $10,000 in 2018, said, "My friends call me Lambo." It went to court. The court said, "No, we're going to still side with Lamborghini. You weren't really known as Lambo. We don't believe all your horse hockey. So we are going to rule that the UDRP stands, that this domain will be transferred to Lamborghini." The person that owned it said, "I'm filing an appeal," filed an appeal, and Lamborghini, the higher court backed up the lower court and said, "No, Lamborghini does have rights, or basically is the winner, and then we're going to reaffirm that decision. Lambo.com gets transferred to Lamborghini. So that's pretty much it, other than if this person wants to try to appeal it one more time to the Supreme Court, which Supreme Court probably wouldn't even listen to this case. But is there anything I'm missing here, guys, on this Lambo.com case? Basically, Lamborghini won it in the UDRP, won it in a court, and the higher court confirmed the lower court's decision. So that's pretty much a done deal.
I'm looking online in the Ninth Circuit docket, and I don't see the decision there. Domain Name Wire's webpage talks about it, has links to a decision, but the links just go to HTML pages, not PDFs, and the HTML pages are blank. So I don't know where he's getting this information from, but I'll wait to see actually what happened. I'm sure there's other options. You can do always an on bank appeal, have the whole full circuit hear it. The other thing is it can go back to court and edit his complaint and make it based on something else. Because I think the key thing here is, well, there's no bad faith at the time of registration. The Ninth Circuit rule is back at the original registration date. So that was a prior owner's registration. It has nothing to do with his current owner's bad faith, whether there is some or not. But I'm sure the $25 million price tag that he had in the lander for years really hurt him. That was a mistake. What do you think, Jeff?
Yeah, I think this guy should quit. Otherwise, he's going to spend a lot more money. And for me, this result was expected. It was a long shot for him to make the argument in the first place about Lambo being his nickname. And he tried, I guess, at the district court level, and anything else either he's doing to try to get a settlement. But to me, this was just not a surprise, and I don't think it's worth the money to spend keeping it going.
Yeah, I think it was a mistake for him to say or claim that it was his nickname, unless he has like solid proof of that. But yeah, we'll see. Well, I want to see what the actual decisions say and the actual filings say.
Yeah, if he would have had a pet named Lambo or just something for real, but the UDRP didn't believe him, that was his nickname. He had no proof of it. The courts didn't. But there was a way that someone could have owned Lambo.com legally and had a good defense, so it wouldn't be taken away from them. And this was the case, if I remember correctly, that Lamborghini had a trademark for the word Lambo, but let it expire, which he thought was really going to be a benefit to him. But they felt like, it's like when someone doesn't renew or do what they need to do to maintain their registered mark, but yet they still use that product name. So they really still have a common law trademark to it. And I think that's what happened in this case, that the court just felt like Lamborghini had a trademark to Lambo, whether they had it registered or not. They showed us that they are known by Lambo. But anyway, this gentleman started off on the wrong foot, and you could never really show the courts or the UDRP panelist that he had any legitimate rights to it. Other piece of news we're going to touch on before we go to our cases is Google released on their blog about why brands really should own their .brand, like Google owns .google, and they made a great case. And for those wondering, if you're a brand and you want to apply in the next round for your brand, reach out to us, tldstrategies.com. Jeff and I'd love to talk with you if you're a brand looking to apply for your brand as a string, as an extension. Google, on their blog and the links on our site, really made a good case for it, saying, listen, if you're a brand, why Google.com is great, but to have home.google is even better. It's safer, meaning everybody can register domains that end in .com, but if you have your own brand, you can limit it to only your brand having domains on that string. And they were talking about they have googleblog.com and it forwards to blog.google. But I thought the article, and like I said, the link is on our website, it really made sense for brands, better than most arguments for brands, that there was, it's safer, you can control it, there's no SEO lost if you do things correctly, and it really can benefit your trademark, really sort of protect you, like I said, because no one can register a .google, only the brand uses that extension. So they did make, I think, some good arguments for owning your .brand. You guys have any thoughts on that?
Yeah, I mean it's the argument that many of us have been making um, for years. Uh, the reason why people do not do it necessarily is because it's fear of the unknown, right? Oh my God, is it going to work? Does it do everything that .com names can do? Similar reason to why people, don't use necessarily other new GTLDs, but absolutely, it makes total sense, and it's your registry to do with it as you please. There's never a fight for availability of whatever name you want to use. And you will be found in search engines. You will, um, regardless of what marketers or other people think they know or say. Um, there's a lot of advertising agencies and marketers that just don't know what the hell they're talking about, and they go to these companies and say, "Oh no, if you change, you're going to lose all your customers and all your SEO," and that's just not the case at all. And for Google to come out and say it should say something, because they're the ones who manage the search results, right? They're the ones who have the algorithm. And if Google's not afraid to put things on whatever .google, then that that should say something.
I remember when Google came out with Bard last year, their initial AI model, and Bard.com got inundated with traffic. It was crazy. There were a lot of comments about that on X.
Yeah, I
But
mean that's true. Like if it is some form of education, but if you have the .com, um, and you forward it, eventually the consumers will figure it out, understand. Search results will reflect the actual true name. Um, but at the end of the day, you know, you're gonna get the search results.
it's not 100% search results, but it's nice to have. I would say it's good for every large company that gets diversified. Yes, they should do that, especially when not all the .coms are available and they just want to reflect their brand in their advertising, but not for a site that's going to get a lot of traffic every day. So it's like a niche type of thing. Um, like, for example, if you wanted to adopt the name Delta, and obviously you're not going to get delta.com, and delta.com is like an airline, I think. But in that case, you can have delta.google.com if you really want to rank for Delta AI or whatever, or Delta Google.
Well, Google wouldn't let you get delta.google. I mean, unless you're, what I think, Jeff, what you mentioned about, sure, been making this argument forever, and then you touched on it. Then still coming from Google really means something. So I know there's a few brands I've spoken with who are like, yeah, tell us about, why we would want to have our own string. And, of course, they always ask us, what are your costs, what it's going to cost us, and so on. Well, the argument, I'm certainly going to share this article about, here's some, what I've mentioned to you, but here's Google's thoughts on it, backing up why a brand would want it. And of course, it's for bigger brands too. Every little small brand's not going to use it or want to spend the money on it. Now, as I mentioned, if you are listening to replay or you're listening live, you're a brand and you plan on applying in the next round, reach out to tldstrategies.com and just click schedule a meeting, and we'll talk about it. Another interesting thing is if you're interested in owning part of a registry, check out tld.fund. There's a presentation there I want you to check out. That's for those who don't really want to apply for an extension themselves, but have always had interest in maybe owning a string, which is really owning part of a registry. Okay, last thing before our cases is I've been saying it for the last couple of weeks. I'll do it for the next few weeks, and that is if you look at our outline, dnlshow.com/outline, I'm asking people to make nominations for the Lonnie Borck Award and for the Trailblazer Award. That's both in the domain industry. You can learn more about them from our outline, but I'm asking that you back me up nominating Jeff Neuman, our own Jeff Neuman, for the Lonnie Borck Award, and nominating Chad Fokening for the Trailblazer Award. I think they're both very deserving of those awards, and once you know more about, you can learn about each one of them online, about the nominees I'm talking about, but also about the awards and why I really feel that way. But I won't spend any more time on it today, but there's links on dnlshow.com/outline to assist you in making your nomination. You don't have to be an Internet Commerce Association member. ICA allows anyone from our industry or outside the industry to make a nomination. Thank you. Okay, now our first case today, SPARC.energy, Spark.energy. Really interesting case. There's this complainant, Commonwealth Fusion Systems versus Eves, is his last name Gaillard? Anyway, EV Domains is the company, but this domain owner was represented by our friend Jason Schaefer. Okay, Jason at Esquire.com, also now operating the domain name law firm. I noticed in this particular case, he mentioned, Jason is a friend out of New Jersey, one of the best domain name lawyers in the space, along with, of course, Jeff, John Berryhill, Zach Muscovich. We got a list of lawyers that we think if you need a domain name law lawyer, you can find them at dnlshow.com. Just click on a lawyer list. But anyway, so Jason was representing this domain owner. Really, oh boy, he did a fantastic job in this case. That's all. That's what I'll say right now. There's tons of facts. I think I'll give a few, and then I'll throw it to you, David, about this was a really tough case to defend against. And that's Zach even said that in his commentary on the ICA website. But this company, Commonwealth Fusion Systems, is on the domain name cfs.energy. But they have this product, SPARC, that is, I don't know, this, I can't even tell you, it's some fusion energy type, I don't know, creator, or I don't even know how to say it. I see Siger in the crowd. He's like isn't he some bionic engineer or something? But anyway, so this is some kind of fusion flux capacitor, some bullshit. But anyway, so this company has a trademark for Spark, SPARC, okay? And they're in the energy space. Well, this domain name, SPARC.energy, was formerly owned by a co-founder of the complainant, and it expired, and then this respondent picks it up. Well, as I mentioned, so he picks up SPARC.energy, and he bought it for $262 just in May of this year, and then he puts up a website with a lot of AI material, and the AI material is, it talks about it has really extensive references to the complainant's Spark project. So you would think that's not good. And then the complainant reached out and said, hey, we used to own this name. One of the guys that worked for us, he's no longer here. We're interested in, getting the name. And then the respondent says, oh yeah, this is, boy, is this a hot name. And it's, a lot of people are inquiring about this. So I'm looking for mid to high six figures. And then the complainant files the UDRP. The respondent changes his webpage because it had all sorts of references to the complainant's Spark project. So then he has this just generic page, and then the case proceeds from there. I could go on and on. David, chime in on some more of the facts and then give the decision. And then, Jeff, you can talk about it. There's plenty to say here. Go ahead, David.
So a couple of things that came to mind was like there was a disclaimer on the website saying that, hey, we're not associated with this energy generator thing, but I think that was as a result of maybe a cease and desist letter. I don't know. There are other trademark owners for the word spark involved in the energy space. There's a Spark Energy drink. There is a Spark Energy company in India. I remember Spark as being a type of architecture for computer chips in the late 80s for reduced instruction set processors that you can run really fast on a Sun microstation computer. And I used to do stuff in the military, so we used them when I was, doing computational dynamics. So that's, the word is a known word. I know that some people might think, oh, well, what if you had a Q there? But that's a totally different scenario. So there's a lot of users of the word spark, so it's a common term, even in the energy space. And the thing that hurt him was that he had a AI generated website on there that referenced the complainant and also had a disclaimer to the complainant. They didn't say what the effect of the disclaimer was, but as we'll see in the next case, they didn't like the disclaimer because it was helping supposedly Cakechella for SEO, which I think is false. But in this case, I think disclaimers are normal, and that was the thing that stood out for me. But other than that, it's like a legitimate thing to invest in domain names. The guy is near retirement in his physician practice, and he's got a portfolio of 400 plus names that are valuable. And we know that energy names sell for a lot. Recently, there was an energy.com name that sold for $350,000. So was he asking too much by asking for mid six figures? Maybe, but it's still within the realm. What do you think, Jeff?
Yeah, well, on the last point, I don't think any .energy name would be worth that much, but hey, I'm not a domain investor, so um, but yeah, to add to some of the facts, I thought it was interesting. Well, first of all, Jason kind of laid it on thick in his defense, and good on him, right? So he basically said, "Look, my client tried to do the right thing. They didn't want pay-per-clicks on there because they know that pay-per-clicks, can get them into trouble, and they know that pay-per-clicks have been used against domain investors, which is all true, by the way." She's like, so we were trying to do the right thing. We're trying to do something different, and so instead of pay-per-clicks, we did this AI thing, which we thought would be much safer, and so we tried to do the right thing. So don't hold it against us if this AI put out results that may be related to the complainant, and essentially saying we don't get paid for. I mean, that was the positive side, right? We don't get paid for clicks on anything the AI generates. So all that weighed in his favor, and I loved the way that Jason kind of laid it on, and it was a great tactic because I think that did absolutely impact the three panelists. Um, I think I also like the fact that they point out that look, Spark is used by so many people in this field of energy, and in fact, even the complainant's own trademark application was opposed, or sorry, was not. Yeah, it was opposed on a likelihood of confusion, or it may have been refused initially on a likelihood of confusion, and they had to argue around it. So, I thought that was a good, helpful fact to say that look, this energy company and their fusion product doesn't have exclusive right to use the term spark, even in the energy industry. So I thought that was yeah, it was a difficult case for Jason. I think he did a great job. I think that that's the reason to hire someone like Jason, or someone who knows about domain names and knows the right arguments to make. And he's going to do a great job. And even the very few cases that Jason loses, and one of those cases actually where he was representing the complainant is also now in court. That's the I forgot the name of the
Fire
fire
Festival. Yeah.
festival. Yeah, that was filed last week too. Yeah, it was a real busy week for cases. In the cases that Jason does rarely lose, he had a great argument and probably should have won. So I think good job, Jason. And this was a tough one.
This would have been a no response. This would have more than likely been a transfer. So Jason did a fantastic job. I'll mention about the Fire Festival case in just a minute. But yeah, in this case, the Jason made this strong case, and then the panel, a three-member panel, Adam Taylor was the chair, but Doug Eisenberg and our own Jerry Levine was the wings on this. And I see Jerry was a wing on the next case too. Um, but so very experienced panelists here, three-member panel, and Jason made this great case that I thought I would have not known spark is a common misspelling of the regular word spark and used in the industry a lot, the energy industry. And it's also an industry acronym, which they never did say what the acronym stands for. I would have remembered it. I mean, they say this is common misspelling in the energy industry. It's also a well-known acronym in the industry, which we didn't have. But so Jason really gave the panel all this information, and then the panel came up with these 6 reasons real fast that one I just mentioned. Number one was it's common misspelling and an industry acronym. Number two, the complainant didn't show that their mark was that famous anyway, that they used it, but not everybody knew about it. But I didn't think that should hold much weight because the this physician who was the domain owner, so he's a physician now. He was a physician. He's retired. I guess he's a domain investor. He picked up this name, and Jason made the case. He picked up this name because Spark, SPARC, in the energy space makes sense, and this physician knew about it. I didn't know because I was like, yeah, it sounds a little fishy, but then it's not. It actually is well known. And then number three, the AI content. Jason said it's not our fault, but I would say if the AI content was a bunch of porn or something illegal, whether it was, I don't know, I can think of gaming or some kind of other, you're responsible for your pay per clicks. You're responsible for your AI content. Okay. In this case, the panel said, you know, what the defense said about the AI content is plausible. They really tried to be safe here, and even AI, they can't control that AI referred to the complainant, but yeah, you just change the AI. You basically edit, but also they said domain trading is legitimate. That was another reason. That was the fourth reason they gave for not transferring it, and then they said the high price doesn't necessarily target the complainant, and that there was some other last thing about the respondent that they liked that Jason said to him, yeah, we were the email we sent back was a little puffery, meaning we were trying to say there's a lot of interest in this. It's a hot topic because we wanted to make the complainant believe that this name is worth a couple $100,000 or into the 6 figures. And the panel said, you have a right to do that. The panel was just like beautiful here. I mean, basically, they denied the complaint, so this domain owner gets to keep the name sparc.energy. The next case, Cakechella, Cakechella.com. You can imagine who the complainant is. It's Coachella Music Festival out here. That's that thing they do in Indio every year. Big concert, big festival. It's arts and music. Versus the domain owner, Amber Foster. Little old Amber out of Virginia. One of Jeff's neighbors. She was doing a little, basically some kind of dessert festival.
Yeah, I didn't hear of it. I wish I had.
She,
I'd be there.
she had a little dessert tasting festival. So what she would do, she, long story short is Coachella's big and said, hey, she's taking advantage of our mark, and people go to her little festival and they're thinking it's related to us, but if not, we didn't, she's not offering something that's non-commercial because she's making money off of it. She's also, it's not a fair use of this thing because we didn't give her rights to do it. So basically, she's making money off of our goodwill, our mark, and so on. And she said, "Listen, you guys got this big festival. I'm doing this thing. It's once a year, 4 hours on a Sunday with a bunch of local people eating desserts from local bakeries. It has nothing. No one's confused. At least she answered, and she answered to the three-member panelists. Like I said, Alan Limberry was the chair. Jerry Levine and Richard Hill. It's like a fucking all-star cast of fucking panelists here. Um, we're listening to this case, and I'm going to let David give you the decision in this case. But she answered back and said, "Hey, I'm doing this very small type thing. The big difference is the scale of what I'm doing, the geography of where I do it at, and really the subject matter. So this eliminates confusion, and the suffix cella is widely used. So I didn't register this in bad faith." She sends it back, her answer, and then lets the panel decide. Go ahead, David.
So I'm very disappointed with the decision. And the reason is because one, the complainant made a claim that they are the exclusive common law and registered, they have exclusive common law and registered rights to trademarks and service marks associated with Coachella. Well, first of all, there are 622 active businesses in the United States that use the term Coachella in their names.
Well, tell them
There
about
are
the decision
52
while you're in.
trademarks.
Tell them what the decision is, so they know what you're unhappy with.
So the decision is a transfer. And the panelists did not do their homework. They really glossed over the essential facts and or the transfer. They basically discounted all of the respondents' arguments, but they didn't challenge the complainant on their false claims. That's fraudulent. You can't say you have exclusive common law rights and trademark rights to the word Coachella when it's the name of a city. It's a geographic location. It's also a region in California. There's a Coachella Valley. So it's a geographic name. And there are hundreds of companies using it in a variety of industries, including the food industry, mostly fruits and desserts, but not baked desserts. And the complainant, their trademarks are mostly for entertainment events and clothing and water, because they sell water at these events. But other than that, they have no exclusive rights to the word Coachella. There's even a Coachella vodka out there owned by Papa Marketing. There is David Herbrowski, who owns a trademark for cookies under Coachella Heat, vegetarian cookies, gluten-free cookies. There's Coachella Moonlight for fresh fruit. So I would say that this decision is a travesty. The panelists did not do their job. When a complainant says they have exclusive trademark rights, I think the panelist has to check and make sure. It's just like saying, okay, I have a registered trademark. They're going to check and make sure, okay, is it still registered? Did it expire? They didn't do their job. And they discounted her claims, even though she has a company registered as Coachella LLC that was incorporated in August, a month before she received the complaint. So whether or not she knows about the Coachella Festival is irrelevant. A lot of people know about it, but a lot of people use the name Coachella. What do you think, Jeff?
Yeah, I mean, this decision just didn't surprise me. And what surprised me is that there was no reference to all the previous Cella um, domain decisions there have been. In fact, we went over one. It was a case in, just looking now, it was in June last year, I think, June or July. No, August, where the mark or the domain was Teachella, like a teacher, Teach Ella. And in that case too, they found the exact same, thing. They found in favor of Coachella. There was a Barkchella. In every one of these cases, the Coachella owner prevails. So I hear what you're saying, David. It's just that there's been no panelist that has found in. I shouldn't say no because there's probably wow. Wait, there's more than I thought. There are. I'm just looking on UDRP tools. There are over 100 um, Cella domain named or UDRPs, and every one of them seems like they're transferred. Now, most of them are, Coachella related, but there's um, a lot of others, like we were just saying, like Bark Cella and T Cella, and uh, other ones that are all in favor of Coachella. So this doesn't really surprise me. It does surprise me that none of those cases were cited by Alan Lindberry, who was the panelist. So I'm not as upset as you are, David. I think it's petty that what the Coachella who they're going after, and I think they could have just settled it by saying, hey, look, you've already done it for this year, or you're doing it for this year. Fine, let's just license it to you. Um, and the other kind of thing is, even with the T-Shell, I didn't kind of like, because it is a case of infringement, or but not cyber squatting. So for me, the reason why all of these Cella cases bother me is because I think the analysis that needs to be done is more of a trademark infringement one than a cyber squatting.
Well, I can.
Yeah. So they lost chelashop.com. So that's one case. That was 2019. But they do tend to win most of their complaints. So I called out David Steele about this on LinkedIn and have some questions for him. But if he actually wrote in the complaint that his client has exclusive rights to the name Coachella, well, that's fraud. And that deserves a complaint to the state bar.
And you're saying Coachella is um, available for others to use, but definitely then Cella would. But I will say this, David. I know Alan and Jerry and Richard would say to you, yeah, we did do our job. You said they didn't do their job. They'd say, yeah, we did do our job. We looked at all the information. It looks like, I would say that they, by looking at that respondent site, which I think the respondent did a fantastic job answering, because the job, like I said, the respondent said, didn't register it in bad faith to sell to the complainant. I didn't register it to prevent the complainant from using it, and I didn't, register it to disrupt the complainant's business, you know, and I believe all that. I think what the panel ruled was they're just not making a legitimate non-commercial or fair use of the disputed domain name. They're actually making a commercial use of it by by using the the reputation and goodwill of the complainant. So by having, even if it's a small little site, and now I'm just playing devil's advocate with you because I'd like to hear a little bit more about um, the the complaint and the full response. But the reason I say this is because I think you look at the website and you realize, okay, this person's doing it on a small scale, but they are, you know, acting like it's like Coachella, but for cakes, Cakechella. They're using the same type of thing. This, it's an event, it's a festival. It just happens to be specific about desserts, but you're making it a commercial site, and you are. But you can make the case that it's infringing. It shouldn't be a UDRP case. But the panel is, I talk to them weekly, and I know they think, listen, it doesn't have to be cut and dry. Nowhere in the original UDRP rules it says it must be a clear-cut case. That's something a lot of us have said, and we keep pushing it forward. But many times there's a case, it may not be clear-cut, and the panelists feel like it does fall within their jurisdiction, or however you want to put it, within their power to rule on. And in this case, they felt like, anyway, they ruled, they transferred it. So I'm like really down the middle on, I thought it was a nice answer by the respondent, but I can certainly understand why the panelists ruled this way. And especially when they look at all the past cases, they would all have to be almost wrong rulings. Um, if it's not they're obviously somebody registered the name and then targeting Coachella. But okay, so we'll leave that one so we can
So
go
I
to,
have a question for
yeah.
Jeff on this case still. So I looked it up, the website as of August 14th, 2025 on archive.org, and they don't have the disclaimer. I guess they put the disclaimer after they received the complaint. And the disclaimer was referenced in the decision, and it was used against them as some sort of SEO tactic. What do you think about using disclaimers on websites, Jeff? Isn't that like a normal requirement once you are aware of confusion?
Yeah, but it happened in for some reason since the beginning of the UDRP, putting up a disclaimer after the case is filed seems to be some sort of admission that you're infringing on their rights. I've always hated that um, in these decisions, right? Because you're trying to say that you're now doing the right thing, but it operates as an admission against your interest when you do that. Um, in trademark actions, yeah, if you do that, you put up a disclaimer afterwards. You're trying to mitigate your damages, and it is kind of one of the things that can help you in a case. But in UDRP, it's always been used against you.
That's very strange. That should change. There should be a court ruling against that. Well, I hope you take this case to help them, the people in Virginia who own this domain name.
The winery. I need to do some more research as to where this is.
Yeah, it's a small event. They're probably not going to want to file a court case,
No.
but the I think what would really to sum this up, the complainant made a strong case that food services competes with what they do, and that's really also what swayed the panel. Meaning, it was too close for comfort. If you were doing, bike cella, I don't know, you'd probably get in trouble for something like that too, a biking event. But anyway, let's get to our last case, and then if we have any questions from the crowd. So the last case, MadisonSquareGardenMusic.com. Okay, I bring this up because this was a domain that was registered just here at the end of June in 2025. Madison Square Garden, MSG Entertainment out of New York was the complainant and said this person, Randy Himmelfarb, I think it's Randi, so I think it's possibly a female, but anyway, out of New York as well, registered the domain name but didn't respond in this dispute. So the complainant said, we've had the Madison Square Garden trademark since 1967. The domain name's pointing to a holding page. There's nothing there, but we're concerned about possible phishing. And since the respondent didn't respond, the Don Osborne was the sole panelist, said, really made it easy for us. She said, okay, 1, 2, 3. They made a good case. They made a case. They're a pretty famous trademark owner, Madison Square Garden, Madison Square Garden Music, um, you know, fully includes their trademark, Madison Square Garden, and the respondent didn't respond. Basically, I bring this case up because if the respondent would have responded and would have shown that if they would have demonstrated that they had prepared some kind of website saying, hey, this is a website that's just to highlight every musical artist that's ever played at Madison Square Garden, and it's a non-commercial site and something of that nature, then they might have had a chance of keeping this domain name. This domain name was transferred away primarily because Madison Square Garden Music, it included the full mark of the complainant. The respondent didn't respond with any reasons why they registered it, even though there are some legitimate ways they could have used it. But really a simple case. I just want to bring up that demonstrable preparations. If you're a domain owner and you buy a domain name with somebody else's mark in it, and you're saying you plan on using it in some legal fashion, you got to show actions. This is for the UDRP. You need to show actions you've taken to develop it out in that legal fashion. Any comments from you on this one, Jeff?
No, it's pretty obvious. I think that yeah, it this is dawn. Of course, you know how it's going to be decided, but I can't think of. I mean, it's conceivable it can, in theory, be used, but you know, I I agree with the outcome of this decision.
So I'm looking on Open Corporates, and there are currently 38 active companies to start with the phrase Madison Square Garden. There's a soccer club in Delaware. There's a promotion company in Delaware. There's companies in Albany, New York. There's companies in um, Boston. There's a Boston Madison Square Gardens. There's a club for a garden place in New York. It seems to be a geographic or a name that's used for a variety of places by a variety of entities. So I think that the complaint was conclusory. I'd like to see a better analysis of that. Did the complaint say to all these entities are theirs or they control them? I don't think they could. So there's a problem with the decision because it is widely used. And if you compare the decision in Spark.energy, there's a huge inconsistency going on here. So when you're represented by a good UDRP lawyer, you tend to win. And when you represent yourself or you don't answer, you tend to lose. That's the pattern I see.
Yep. And about okay, so I wanted to mention quickly, and Ragu, I invited you back up if you have a question about the blockchain case. So take a look at your whatever your invites and see if you can come up here as a speaker quickly on what Jason Schaefer, he had filed a complaint, a UDRP complaint against this person that owned firefestival.com, and he was unsuccessful in his complaint, meaning they denied the complaint and the domain owner got to keep the name. Jason and his client were unhappy, really couldn't believe it, thought it was a bad decision, so they filed a ACPA case. It's what you file when a UDRP doesn't go in your favor, whether you're a complainant, you didn't win, or you're a respondent and you lose. If you don't like the UDRP decision, your your best bet is to file an ACPA. I guess you probably could file a Lanham Act case for some instances if it's some infringement bullshit. But the point is, so Jason is not giving up on firefestival.com, and on behalf of the owners of that uh, trademark, they're going to court. So we'll follow up with Jason and find out what happens with that. So, no, I see. Is Ragu a speaker? I think he is now. Ragu, go ahead. Thanks
I
for
think that's
joining
a
us.
lost cause.
Yeah.
That Fry Festival domain name is a lost cause. The original owners who had the copying law rights went into bankruptcy, and there was no transfer to the new entity.
Yeah, I don't know. We'll have to hear from Jason why he feels, because somebody's spending money to file this court case. But all right, so we can wrap up. Ragu, go ahead. Thanks for joining us.
Good afternoon, Todd, Jeff, David. I wanted to ask Jeff, especially about this blockchain.ai. So the person I understand is a time-sensitive issue because of you wanted to stop the auction. But if it's not the time-sensitive issue, would have it taken to a UDRP case? Maybe not. It is more like a court case type of case. But the real question I wanted to ask is uh, the cost involved, right? I can understand everybody's okay with that because of the the size of this domain name, blockchain.ai. But averagely, if someone gets up and try to prove his point, even though I don't know which way to look at this case, expired or not paid or visa expired or whatever the reason is, the bottom line is it's not under his control. It's too late. Now the cost involved. Who will bear the cost? Um, Either way, either when you win or you lose, and it is worth it. Like in this case, probably it's worth it because it's a big name. With average name, based on this kind of dispute, what kind of money coughing up by the plaintiff or defense, and how is get sort out the expense of this kind of scenarios? This is what my question was. Thank you.
Yeah, it's a great question. And in the United States, it's not always so easy to recover attorney's fees if you win the case. Um, this case, I see, there's allegations of willful breach of, you know, if Howard can prevail in California, and I'm not, you know, prejudging it as to whether he will or won't win, but there's claim in there for damages, um, and if a court were to find something like conversion, which is theft, you would be entitled to recover attorney's fees. But that's not true in all cases. Like in the Prosecco.com case, yeah, we're asking for attorney's fees, but at the end of the day, it's not always easy to get attorney's fees from the court. So you could be spending a lot of money, but if the name's worth it, if the name is one where which your business relies on, it's going to be important to spend the money. But if you're a domain investor and you think the name is worth, under $50,000, is it worth paying to go to court? I don't know, right? There's a cost.
Well, Jeff, have you ever had a case that cost less than $50,000?
That's why I said if it's less than $50,000, I would not. It's not one that I would want to necessarily take to court. But
Yeah,
some people,
that is the dilemma. I mean, I'm always first to say, and I don't know why it's me always. I probably have this type of scenarios, and I will, with the grace of, I will let it go because it's not worth it. And I see the clear picture. Someone is trying to be smart enough, or if it's a company, like how do you cope with these kind of dilemmas? And I'm sure investors would probably go through this sometimes in their lifetime. And I just been through this and twice. One with from the auction, one from the actually visa. This issue of not expiring or not renewing on time, and still trying to recover it. And they choose to take it to the auction rather than resolving it by paying the redemption fee. It was so easy for them to say, okay, pay up, we'll recover this for you under redemption. And because they still have a control, but they choose to go with the auction because maybe it's more profitable for the host to do this way. So, and you let it go because it's not $50,000 domain, is not $10,000 domain, is maybe $2,000 domain. And then what you do, you just have no choice. Just okay, gave up on it, right? So it happens to us all the time.
I think it happens to us all the time in every line of business, right? A customer I may have a customer of my or client of my law firm, and they, may owe me $10,000, $15,000, and the question is, do I go to court to try to recover it? It's a question everybody faces in every line of business. There's always something. Um, that you have to stop and consider. Monty, I know, who runs domain auctions, right? Right of the dot, who does a bunch of domain name auctions, right? He's got, fortunately, there have been customers in the past that haven't paid or that breach in some sort of way. Monty goes after them. Monty goes after them because he feels like it affects the credibility because he's a broker, essentially, when he's auctioning these names. And he feels like it's important for his buyers and his credibility to go after, some of the even smaller cases because he wants to be able to represent to the sellers of these names in the auction that I'm going to fight for you. If someone bids and someone wins an auction, I'm going to go and collect. And if I have to bring a lawsuit to do it, I'll do it. Not everyone is in a position to do that. And so I sympathize with your um, dilemma. And yeah, it's only going to be these big names that likely will get um, people trying to enforce.
Good
Yeah,
question,
there was
Raghu.
that IMI.com case, I think, that Mark Rodenbach or Mike Rodenbach litigated in Northern District, California. Actually, no, he just did the trial. He charged over $400,000 just for the trial, a jury trial. So you're talking serious amount of money. Had he taken over the case at the beginning, it might have been more streamlined and settled. But hiring an attorney at the last minute just before trial, he charged top dollar. And I guess he had a couple of juniors with him, and it was a runaway train without expense. But 400,000.
I mean, now getting involved in more litigation, it's a lot of time. It's very time consuming, and the amount of attention to detail and it takes up a lot of time. And so, yeah, I mean, attorneys, yes, aren't cheap, but um, you hire a good one, it's gonna cost you a little bit more.
Yeah, and not only that, I would look at the point of view whoever won the bid. Now it's another party got involved. Okay, I bid on it, I pay for it, I'm ready to pay for it. Now what? So it is now another party got involved for no reason or with a reason. I have no idea. This news came out in the same time when the auction was taking place. Um, so
Right, but remember,
imagine.
there's such a short time period for this auction to take place
That's right.
because it's only um, pending delete's only 5 days. So by the time that Howard found out that he no longer had possession of the name, it was 4 days and counting. And um, could I, in theory, have or could a lawyer, in theory, have filed a TRO? Maybe a day earlier than he did, or 2 days earlier, possibly. But that would probably have been an all nighter, I'm sure, to get that filing in. But, that wasn't the very first thing you think about is not, I want to go to court immediately to stop it. It's, hey, can I get the registry in this case to just stop the auction for now? And I honestly thought when I sent that letter that the registry would put a little bit of a hold on it, at least to figure out what's going on. And then, it could have put a hold on it. And if it determined that this claim was without merit, it could have auctioned that off 5 days later, 10 days later. It wouldn't be like, and you can even get more, in theory, you could get more press announcing your auction and holding it like 10 days later. So I honestly thought, and of course, the client doesn't want to immediately go to court and rack up that kind of expense. You
Yeah,
know,
and matter of fact is, I already paid $400,000. I want this name in my account today. How that could happen? And middle of this dispute. Now, that's what I'm saying.
well, but as the buyer in this case, the buyer hopefully is now on notice, right? So yes, the buyer paid 400,000, and yes, if the buyer has to give up the name, the buyer will be entitled to a refund. Um, it would be hard for the buyer to say, I paid and I relied on that and I went out and spent all this money already in reliance on owning that name. That's similar to my case um, in the color.com and butane.com case. My clients had the name for 60 days without any kind of notice that there was any issue, and they went out and spent a ton of money, not just promoting it as a domain investor, but going out and starting real businesses. And they spent a lot of money, and that's why we're in court. But if it had been noticed that there was an issue with the auction the day after, 2 days later, or if they had noticed when they bought it, then that would be a completely different story. Here, the buyer should have noticed that what they bought is subject to a legal claim. And Identity Digital, Namecheap, only domains should be putting, if the buyer didn't see it when it was posted during the auction, because I know that Mike had posted during the auction, which Namecheap, by the way, kept deleting. I think that was a mistake. But
Sorry, what was deleted?
So if you look at, well, I don't know if you can go back to the auction site now, but if you looked at the auction site the night before the auction completed, Mike Rodabaugh posted what he posted on Twitter essentially as a comment to the auction. Namecheap deleted it. Then Mike posted it again the morning of the auction, and within 10 minutes, Namecheap deleted it. Mike then posted it again, and sure enough, Namecheap deleted it. Mike then tried to, from what I understand, post it under a different name, and he ended up being blocked, and they deleted it. So, um,
I
you
think
know,
all that activity actually hurt his client, and I'll tell you why. Had he not done that, had he stayed quiet, then the domain would have sold at auction for more money because a lot of people stayed out of the auction knowing that there was a legal claim to it.
yeah,
So,
but that's not his goal. His goal wasn't to get as much money as he can. His goal was to get the name back, right?
well, he's not going
And
to get it back by filing a case in California.
sure, you can conversion, theft of property. Look at the Kremen case.
All right, I'll take a look at that. But it's not going to happen anytime soon. It's going to take years of litigation. It's going to cost a lot. If you want to stop the auction, just file a TRO in Arizona on Friday and it's done.
Arizona doesn't recognize that it's property.
And we don't know if the name's been transferred yet, so the TRO still may mean something if it's ruled on today
Sure.
and there hasn't been a transfer. But Regu, you bring up a
But
good
Mike,
question.
but by posting it, Mike's now put the buyer and others on notice. Beware, right? And so I think from a court perspective in the case, that could be seen as a beneficial thing that Mike, that the client wasn't interested in, you know, didn't care if the value of the name went down because that's not his goal. His goal is to get the name back, and he did everything he could to put the buyer on notice that this was subject to a valid legal claim. And yeah, maybe did it lower the amount that was ultimately bid? I don't know, but when that's not your goal, I think the fact that he put everyone on notice, including the buyer, means that if the buyer now goes out and spends money, gets the name and spends money developing it, it's doing so at its own risk, knowing that there's a legal claim, and so that the buyer is not going to be able to go to court and get anything more than a refund of what it paid.
Yeah, and this could get real messy because the buyer could say, hey, Namecheap didn't disclose to me or Identity Digital. So what Mike is doing was for some reason, he has reason. We're going to see how it plays out this week. I'll reach out to Mike and see if he wants to come in and talk about it. Right now, in the thick of stuff, he probably doesn't. He's thinking, the smart guys, he knows what he was doing when he posted that stuff. And for the reason of if it's not being disclosed to this potential winner at that time, whoever the winner is, he's disclosing it to him in his own way. And I wonder if Namecheap or Identity Digital or anybody did say anything, probably not, to that buyer. It's like, hey, it's time for your payment. Did they say, keep in mind that we have received the, but I will say Richard over at Namecheap sounds like he's like, until I get something that's from the courts, I'm not believing any of you lawyers and any of your stuff. And it's really to his own detriment. Why would he do that? And he just did the big deal with the company. So, I mean, even if you don't like lawyers, you don't have to say, I don't, don't, all the stuff you come to me with before it's actually filed in court and I get it from, a
Well,
notice.
and the reality is he was or should have been on notice because the company did receive emails um, prior to several days prior to the auction closing. Now, whether his lawyers conveyed that to him or the lawyers did anything, the company was on notice days before the auction closed.
Right, and you're right, and he has lawyers there too. So I'm assuming every action that he took was approved by his lawyers. Okay, so we're going to close. But Ragu, I wanted to say, great question, because if you are in a situation, Jeff said it, like Monty didn't get paid, say, on a $9,000 name. He auctions it off. It's $9,000. The buyer doesn't pay. Monty knows it costs more than that to go after that buyer who non-paying bidder. But sometimes you have to do it. And some things you can do, even if you have a low valued name and you think, damn it, I lost this in a UDRP, or I just flat out, somebody's filing a lawsuit against me. Reach out to Jeff, reach out to one of these domain name lawyers and say, tell them your whole case, meaning usually the consultation will be free. This lawyer can tell you, you know what, you can always say, hey, can we work something out where I'm going to cap on my expenses so I can have you try to settle this quickly and I only have 10,000 to spend or 20,000 to spend. Talk to the lawyer about that. The lawyer may think, hey, you know what? This is a case that I'll take on contingency if I can recover the attorney fees via, request it from the court, and I think I have a good shot. Maybe they'll do that, or maybe they'll like the case for some reason because of the name, the industry that it's in. They may take it as a pro bono case. So always, before you decide, like, damn, I can't afford this, because not a lot of us are going to be spending hundreds of thousands, even 50, but a lot of money on a court case. Reach out to the pros, explain your situation, and sometimes there's ways that you can still make it happen. If you have a little bit of capital, sometimes even none, like I said, cases, can be taken on contingency or just flat out pro bono. Or like I said, you can mention, I have limited resources, so I need a cap on the expenses. What can we do here? Because I don't want to lose my property. So don't always just give up. Ask pros how they can help you, and you'll be surprised. There's always ways to make things happen. Well, I appreciate everybody being here. Thanks for sticking around. Thanks for listening on replay. For those of you listening on replay, I wanted to say Ragu and Yusuf have this great room they do every once in a while now. So outside of Ish's room on Saturday, and then of course Josh and I do the DNX show on Thursdays here on X. So be there on Thursday, 10 a.m. Pacific, 1 p.m. Eastern. Ragu and Yusuf, my new favorite fucking team. It's like fucking Tom and Dave, or what are those guys from the Canadian. Anyway, it was a really enjoyable room they had the other day. I hope they have more here on X. Until Thursday, we'll see you then. Have a great rest of the day wherever you're at. Take care, everybody.